Before diving into our next topic, let's have a quick review. Remember when we said that misstatements can be caused by fraud, error, and non-compliance? Well, now is the time to talk about non-compliance with laws and regulations, or in the accountant's jargon, NOCLAR. Prior to embarking on an audit engagement, we have to get to know our clients, a GTKY of sorts. And one of the things that we have to know is the client's legal and regulatory framework. The legal and regulatory framework is composed of the laws and regulations to which an entity is subjected to. Understandably, the effect of these on the financial statements vary from industry to industry. There are some laws that have a direct effect on the financial statements, while there are others that are required for operations but do not necessarily have a direct effect on the financial statements. An example of laws and regulations that affect the financial statements directly would be, quite obviously, your accounting and taxation rules. Examples of those which are required for operations but not necessarily affect the FS directly would be CHED regulations requiring full-time faculty of universities to be at least a master's degree holder. It must be noted, however, that whether the effect on the FS is direct or indirect, non-compliance with either or both can result to fines, litigation, and other consequences that may have a material effect on the financial statements. Take, for example, a company that has failed to follow regulations regarding proper waste disposal. The said regulation does not have a direct effect on the FS, but once violated, it can lead the company to pay fines or worse, be closed. These fines may have a material effect on the financial statements. A closure, on the other hand, brings into question the going concern assumption. Before we go any further, let us first understand what exactly is non-compliance. PSA 250 defines non-compliance as acts of omission or commission, either intentional or unintentional, which are contrary to prevailing laws or regulations. This means it is something that the client has either excluded or included, did not do or have done, either fraudulently or mistakenly. For as long as it is against laws or regulations, it is considered non-compliance. Be warned, however, that it does not include personal misconduct unrelated to business by those charged with governance, management, or employees of the entity. Now, what are the responsibilities of client management? It is the responsibility of management, with the oversight of those charged with governance, to ensure that the entity's operations are conducted in accordance with the provisions of laws and regulations, including compliance with the provisions of laws and regulations that determine the reported amounts and disclosures in the entity's financial statements. It is also their responsibility to prevent and detect non-compliance with laws and regulations. Very similar to their responsibilities for fraud and error, right? What about the external auditor? At the onset, let us point out that the responsibility of the auditor has not changed. He is still responsible for obtaining reasonable assurance that financial statements taken as a whole are free from material misstatement, whether caused by fraud or error. But since non-compliance can be either fraud or error, it is to be expected that the inherent limitations are greater for NOCLAR for the following reasons. Number 1. There are many laws and regulations relating principally to the operating aspects of an entity that typically do not affect financial statements. Number 2. Non-compliance may involve conduct designed to conceal it, such as in the case when it is fraud. And number 3, whether an act constitutes non-compliance is ultimately a matter for legal determination by a court of law. Obviously, the farther the non-compliance is from the items in the financial statements, the less likely the auditor would be able to recognize it as non-compliance. To understand the auditor's responsibility with regards to non-compliance, let us pull up our previous illustration of the client entity's legal and regulatory framework. It is the auditor's responsibility to obtain a general understanding of the client's legal and regulatory framework, as well as how the client is complying with such. With regards to laws and regulations that have a direct effect on the financial statements, the auditor is responsible for obtaining sufficient, appropriate evidence about its compliance. For those laws that do not have a direct effect on the FS, the auditor has to perform specified audit procedures regarding its compliance. What specified procedures are these? Well, inquire from management and those charged with governance with regards compliance, and inspect correspondence with licensing and regulatory authorities if there are any. The above-mentioned procedures of the auditor will yield either one of two things. Is there identified or suspected non-compliance? If none, the auditor is not required to perform any more procedures than the ones already done. But what if there is an identified non-compliance or suspected non-compliance? The auditor must first obtain an understanding of this instance or suspected instance of non-compliance. He must also obtain further information sufficient to make him evaluate the potential effect of this on the financial statements. The auditor must obtain information for him to be able to answer questions such as, what are the financial consequences of this? Are disclosures needed? And is the potential consequence so serious that we begin to doubt the fair presentation of the financial statements? After obtaining the necessary information, the auditor then documents his findings. He then discusses these with management and, where appropriate, those charged with governance. If management fails to provide him with information to prove that they are indeed compliant, the auditor must seek legal counsel, as non-compliance needs legal determination. He may first seek legal counsel from the client's own legal team. However, when it is inappropriate to do so, or if the auditor is not satisfied with the legal counsel's opinion, he may consult his own legal counsel. After these discussions, the auditor then evaluates the effect of this non-compliance on the financial statements and the audit opinion. Similar to our matrix on fraud, if the auditor has determined that there are misstatements owing to non-compliance, he must first ask management to revise. If management says no, then the auditor should consider whether a qualified or adverse opinion is necessary. However, if the auditor is precluded from gathering the necessary evidence due to scope limitation, then the choice is between qualified or disclaimer of opinion. Like I said, very similar to our matrix on fraud. Aside from the effect on the financial statements, the auditor must also evaluate the implication of the non-compliance to other aspects of the audit. He starts asking questions like, do I need to reconsider the risk assessment that I made for this client? Is it more risky than I thought? And do I have reason to doubt management's written representations in light of the non-compliance? Is management refusing to cooperate? Is there a basis to suspect that management and those charged with governance are involved? Is there a need to withdraw from the audit? Of course, upon completion of the audit, the auditor must obtain written representations from management. But then I think the more interesting question is the one that many of you have been asking for quite some time now. Can the auditor report non-compliance? PSA 250 and the NOCLAR initiative of the IESBA have the answer. PSA 250 provides for 3 reporting avenues: reporting to those charged with governance, reporting through the audit report, and reporting to regulatory and enforcement agencies. Let's take the first avenue. Unless all of the TCWG are involved in the management of the business, the auditor must report identified or suspected non-compliance to them. This is especially true if the auditor suspects that the non-compliance is intentional. However, if the auditor also suspects TCWG to be involved in the non-compliance, he must report it to a higher level, like the audit committee if any, or if none, he must seek legal advice. The second avenue is for us to communicate via our audit reports. Our audit report is one of the auditor's most powerful tools of communication to the public. When an auditor modifies his opinion, it alerts the readers of the report, especially government and enforcement agencies. When an auditor modifies his opinion, this sends a message to the readers and can be used as a springboard for inquiries and investigations to be conducted. This is the reason why, even when the auditor is bound by confidentiality, his integrity remains intact for as long as he issues the appropriate report. The third, and perhaps the least explored avenue, is reporting to regulatory and enforcement agencies. This avenue has been the topic of much debate, especially when taken into the context of the auditor's duty of confidentiality. This is the reason why the International Ethics Standards Board for Accountants created a framework for dealing with NOCLAR. The IESBA project was started and the framework was created owing to three reasons. Number one, the duty of confidentiality seems to have been abused as a barrier to timely disclosure of fraud and other NOCLAR to authorities in the public interest. Number two, auditors resign because of NOCLAR, but there is no assurance that the matter was subsequently resolved. And number three, there is a lack of guidance in the Code of Ethics on how to determine the appropriate course of action. This is the framework for NOCLAR. The external auditor must first raise the identified or suspected NOCLAR with management and TCWG. This will serve to clarify their understanding of the matter and substantiate their concerns, and to ask them to investigate and rectify. This step will also allow the auditor to advise management to address, mitigate, deter, and disclose, where necessary, the instance of NOCLAR. The auditor must fulfill its professional responsibilities. This includes understanding and complying with applicable laws and regulations, including whether there is a requirement to alert the authorities, complying with auditing standards, and required communications to management. The auditor then determines if further action is needed. The auditor has to assess the appropriateness of the response given by management and TCWG and objectively determine if further action is needed. It has to be pointed out, however, that whatever further actions that the auditor deems necessary will depend on the following: credible evidence of substantial harm to the entity and shareholders. This is very important and also very difficult, especially since we do not make legal determinations. However, should the auditor wish to bring forward further action, he must be able to support his claim with credible evidence. Urgency and pervasiveness of the matter. How widespread is the effect, and how urgent are the expected consequences? Is it allowed under the law of the relevant country? Are there any laws prohibiting disclosure of confidential information to an outside party? For example, will the information that you plan to bring to the authorities be covered by the Data Privacy Act? Does it not violate the bank secrecy law? In making this decision, the auditor must apply the third-party test, meaning to say, would the third party, weighing all the specific facts and circumstances at the time, likely conclude that the auditor has acted appropriately in public interest? Now, what exactly are these further actions that can be taken by the auditor? The auditor may disclose the matter to an appropriate authority, even if not required by law. Be reminded, though, that this can only be done after considering the nature and extent of the actual or potential harm to stakeholders, whether there is an appropriate authority to intake and follow up on the information, the availability of legal protection, and the existence of actual or potential threats to the physical safety of the auditor or others. He may also choose to withdraw from the engagement and the client relationship. If this is the route that the auditor wishes to take, he must inform the successor of the NOCLAR when inquiries are made and permitted. Perhaps you have also wondered, can you directly report to the authorities without alerting management first? The answer of the IESBA? Yes, but only in very exceptional cases. These exceptional cases would be when there is an imminent breach that would cause substantial harm to the stakeholders. Therefore, with this new framework, an auditor is not automatically silenced by the duty of confidentiality, nor is his recourse only limited to resigning from the engagement. It must be pointed out, however, that should the auditor decide to report to authorities, the conditions must be present and legal advice must be sought. Lastly, the auditor must document courses of action considered, judgments made, and actions taken. So there you have it, the auditor's responsibility on NOCLAR. We have just completed the three sources of misstatements: fraud, error, and noncompliance. You may check out a copy of the summary of the IESBA NOCLAR framework on the following links. Thank you very much. Up next, are you curious to find out what the auditor's legal responsibilities are? Stay tuned.